The United States stands on the precipice of a constitutional crisis. The Trump administration's potential defiance of federal court orders has set the stage for a showdown between the executive and judicial branches. This clash, with its roots in the very foundation of American democracy, threatens to unravel the delicate balance of power that has long defined the nation. The stakes are high, and the outcome remains uncertain. At the heart of this crisis lies a fundamental question. Can a president simply ignore the rulings of the judiciary? The answer, steeped in centuries of legal precedent and democratic principles, is a resounding no. The principle of judicial review, enshrined in the landmark case Marbury v. Madison, grants the judiciary the power to invalidate actions of the executive branch that violate the Constitution. This power, a cornerstone of American democracy, acts as a crucial check on executive overreach and ensures that the government operates within the bounds of the law. However, the Trump administration's recent actions, particularly its defiance of a court order halting the deportation of Venezuelan nationals, have raised serious concerns about its commitment to upholding this fundamental principle. This case, a microcosm of a larger struggle, has brought the nation to a crossroads. The administration's actions have sent shockwaves through the legal community and beyond. Legal scholars and practitioners alike warn of dire consequences if the executive branch continues down this path. The erosion of judicial authority, they argue, would undermine the rule of law and plunge the nation into uncharted and dangerous territory. The very fabric of American democracy, they caution, is at stake. The current crisis came to a head with the case of Venezuelan nationals facing deportation. Judge James Boasberg, Chief Judge of the United States District Court for the District of Columbia, issued an order barring the Trump administration from deporting these individuals. This order, grounded in legal precedent and humanitarian concerns, represented a direct challenge to the administration's immigration policies. The administration, however, chose to disregard the court's ruling. Despite the judge's clear and unambiguous order, the Trump administration proceeded with the deportation flights, sending shockwaves through the legal community. This act of defiance, unprecedented in modern American history, raised profound questions about the administration's respect for the rule of law and the separation of powers. The administration's actions, legal experts argued, amounted to a blatant disregard for the authority of the judiciary and a dangerous erosion of the checks and balances that underpin the American system of government. The administration, in its defense, claimed that it had not intentionally defied the court order. Instead, it argued that the deportations were already in motion before the judge's ruling and that logistical challenges prevented them from being halted in time. This explanation, however, did little to quell the growing outrage among legal scholars and the public alike. The timing of the flights, many argued, seemed suspiciously convenient, and the administration's overall disregard for the court's authority raised serious doubts about its commitment to the rule of law. The Venezuelan deportation case, though seemingly isolated, has become a flashpoint in a much larger debate about the balance of power in American democracy. The administration's actions in this case, legal experts warn, could have far-reaching consequences, setting a dangerous precedent for future executive overreach. The outcome of this case, and the broader struggle it represents, will have profound implications for the future of American democracy. In an attempt to justify its actions, the Trump administration raised a novel legal argument, that oral orders from judges are not binding until they are issued in writing. This argument, largely untested in the annals of American jurisprudence, sent ripples of astonishment through the legal community. Legal scholars, both conservative and liberal, roundly dismissed this claim as baseless and a blatant attempt to circumvent the rule of law. The administration's reliance on this argument, many argued, revealed a fundamental misunderstanding of the judicial process. Oral orders from judges, while not always immediately transcribed into written form, carry the full weight of the law. To suggest otherwise, legal experts argued, was to undermine the authority of the judiciary and create chaos in the legal system. The very notion that a president could simply ignore a judge's verbal order, they warned, struck at the heart of the rule of law. Former federal judge Shira Scheindlin, a respected voice in legal circles, dismissed the administration's argument as unprecedented and absurd. Oral orders, she pointed out, are a routine part of court proceedings, and their validity has never been seriously questioned. To suggest otherwise, she argued, was to engage in a dangerous game of legal sophistry. The administration's attempt to create a distinction between oral and written orders, she cautioned, was a dangerous precedent that threatened to undermine the entire judicial process. The argument over oral orders, while seemingly a technicality, goes to the heart of the separation of powers and the rule of law. The administration's attempt to exploit this issue, legal experts warn, is a dangerous ploy that could have far-reaching consequences for the American legal system. If the administration is successful in its claim, it could open the door to widespread defiance of court orders, eroding the authority of the judiciary and undermining the very foundation of American democracy. Former federal judge Shira Scheindlin's warning about the perils of defiance could not be more timely. The Trump administration's actions, she argues, demonstrate a dangerous disregard for the judiciary. This defiance, if left unchecked, threatens to erode the very foundations of American democracy. The stakes have never been higher, and the path forward remains fraught with uncertainty.
Ladies and gentlemen, as we conclude this critical discussion, let us reflect on a fundamental truth. No one, not a citizen, not a president, not a former president, is above the law. The rule of law is the bedrock of our democracy, and its strength lies in our collective commitment to uphold it, even when tested by power or defiance. In America, the judiciary serves as the guardian of accountability. If we permit exceptions for the powerful, we risk normalizing a two-tiered system where influence trumps fairness. Let us leave with this resolve: the courts are not helpless. Their power lies in the courage to act and in our collective demand that they do so. Democracy thrives when every individual, regardless of status, answers to the law. The moment we tolerate exceptions is the moment we surrender the very ideals that define us. In the words of Justice Brandeis, if the government becomes a lawbreaker, it breeds contempt for law. Today, we affirm that no one is exempt, and that when the courts speak, their voice must be heard.